Good afternoon, everyone. Thank you so much for joining us. Uh, as Michael mentioned, this is Dealing with Defaults, which is episode 3 of the Financial Ploys Business Borrowing Basics series. You can read more about financial ploys on slide 53, and slides 6 through 8 will summarize this particular episode, as well as provide you with a list of the episodes that are in the Business Borrowing Basics series. I have the pleasure today of being your moderator. I'm a partner in the corporate practice group of Dwayne Morris, and I am thankfully joined today by some great panelists. So let's introduce you to each of them. First, we have Phil Buffington, who's a partner in the Banking and Financial Services team of Balch & Bingham, LLP. We also have Jonathan Friedland, who is a partner at Much Shellis Law Firm and is also the publisher of the National Law Review. The National Law Review is our co-producer today, and you can find information about it on slide 3. We also have Harvey Gross, who's the founder and president of HSG Services, as well as the executive director of the New York Institute of Credit. And so we like to keep all of our introductions here short and sweet and not provide too many infomercials. But if you're interested in learning more about the panelists or myself, you can find our bios on slides 58 through 50. And speaking of the slides, so in this webinar, we will not step through each slide deck, and we will not be reading slides. This webinar, like all of the Financial Ploys episodes, are and will be a conversation, but definitely keep that PowerPoint handy because I will try to indicate as we go through our conversation what slides we're touching on, and the slide deck is a great reference tool for issue spotting when you need to be reminded of what you've discussed today. If you are attending the live premiere of this webinar, you can submit questions to the web portal. If you are watching this on demand and have questions after you have attended the webinar, you can send in questions at info@financialploys.com. Just include your question and the name of the webinar episodes, and we will do our best to get you an answer as soon as possible. All of this information is also available for you on slide 55. And as I said, this will be a conversation, and this conversation is for informational purposes only, as slide 5 states. So in short, we are not your lawyers, we are not your bankers, we are not your advisors or accountants. Everything very much is determined by the circumstances of your business, so make sure you use appropriate professionals to determine what works best for you. And so now that we have all of the housekeeping and introductory items out, let's get ready to dive in, guys. So as I mentioned, we're in episode 3. In episode 1, we talked about, what types of loan businesses might look to get depending on their circumstances. In episode 2, we talked about the types of things and terms that may be applicable to all borrowers. And as what happened with any loan, sometimes things don't go as the business expected. And so here we are, and there may be a default. Now that default can be a payment default, that default can be another type of default. But let's see, Jonathan, does it matter the type of default that they may enter into?
Yes.
And when you have
Wait, no, I was trying to be funny by giving you a one-word answer. I was going to expound.
Oh, please do.
Oh, yeah, it matters a lot. First of all, let's make sure we're clear on definitions, right? A payment default is exactly what it sounds like. A payment, whether it was interest or principal or both, was not paid when and as due. Very black and white, either it happened or it didn't happen. And payment defaults tend to make lenders very angry very, very quickly, as opposed to a covenant default, which is a breach of it's a default of any other kind. So it's a non-payment default. It's a default of a covenant, a rep, a warranty. I'll stop there so I don't monopolize, but basically that's the landscape.
And does it matter the size of the default when it comes to the size of the company, I guess, when it comes to the default and how the bank may react, just in your experience.
Sure. So, there's a number of general dynamics about any situation that really tend to be drivers, more so than others. Is the was if there's a default, was it caused by absolute incompetent negligence versus unforeseen business circumstances versus dishonesty by the D's and the O's, or the owner, the D's and O's. Another, and there's a litany of factors that I kind of think of as sort of these broad macro factors. And you asked about one in particular, which is right up there, the size of the business. And size matters. That's a double entendre. If you've got a larger company, you're more likely to have assets across a number of jurisdictions. And if you've got assets across a number of jurisdictions, and if some sort of insolvency regime is necessary to address the situation, that's a fancy way of saying, bankruptcy, an assignment for the benefit of creditors, receivership, Article 9. As a baseline rule of thumb, if it's a smaller company with assets within a single state, then you're, all else being equal, more likely to maybe be able to avoid a bankruptcy. Whereas if you've got assets all over the place, it may make more sense to use a bankruptcy. A larger company versus a smaller company is also likely to simply have more issues. Your typical 5-employee business isn't unionized. The larger the business, the more likely it is unionized. And if it's unionized, that creates a whole host of issues that simply don't exist, that in the absence of a union. That's just an example. Actually, again, I'll self-regulate and stop talking for a minute.
Yeah, I mean, it sounds like, as with many things that we discuss and will continue to discuss, the facts and circumstances definitely tend to matter.
Hey, Jackie.
Yeah.
I just wanted to mention, as Jonathan obviously gave a lot of great comments, we had in our industry, in our factoring industry years back, we had a lender. And what he used to do, which I don't know if it bordered on anything that was lender liability or anything like that, but what he would do is he would structure the agreement so it would be very hard for the borrower to stay within compliance, so that a default would actually be obviously happen. And what he used to do to cure the default, he would then turn around, put in a surcharge, and add a couple of years to their contract. So it was almost like the normal way of doing business and not the exception in what he did.
Mm-hmm.
Others have tried to follow that in some way, and that's why I know later we're going to talk a little about giving borrowers advice on things. But I just figure I mentioned that when we're talking about defaults. That was something that was done probably about 20 years ago.
It's interesting. I'm going to layer on to what Harvey layered on. So it certainly does not sound like the player, the actor that Harvey's describing was a loan to own lender. That's not what Harvey described. However, it makes me think of the concept. And so again, there's certain baseline facts that an experienced restructuring attorney will ask a could-be client right off the bat to sort of get a temperature of the situation. And Harvey made me recall the type of lender that you've got. If you've got a loan to own player, very different than if you don't. And then there's other sorts of lenders. We could get into how the care and feeding of different types of lenders will dictate how, basically, it's often somewhat outcome determinative without even knowing any more facts, who the lender is.
So, Jonathan, it's funny you mentioned that. Loan to own is something which is really the dirty end of our business, and people don't want to admit to it or talk about it, but we know there are people who do it. I was actually at a conference several years back, and they did a part of one of the panel discussions was loan to own. And they talked about how they do it. And I just couldn't believe that they admitted in a big audience how they do a plan to loan to own. And it was just very unique. I just figured I'd mention that.
Jackie, I just want to add 2 points, and I think it's going to be a little bit redundant, but just kind of sum it up from a creditor standpoint. I think 2 big issues whenever you're dealing with a default are going to be cash flow and collateral value. And Jonathan covered all of that, but I really think people need to understand that those are going to be 2 huge triggers for any creditor.
Right. And that collateral will definitely depend on what you've granted as collateral, including whether or not you have potentially even granted, depending on the type of loan, any personal guarantees and things of that nature. And I would imagine the appetite for some lenders, depending on what's happening from a macroeconomic perspective. So, we've definitely gone through times where we've had lots of companies that have had defaults happening sort of back and back versus when, things are going well and maybe not that many people are defaulting on their loans. So let's talk about some potential examples as we get into some of the facts. So Phil, let's think about, a company, let's make it a manufacturing company with about 100 million in revenue. Their assets really are, their AR, the inventory, the equipment, maybe some IP. And, that company has looked at several lenders and that are competing to provide them financing. What would you say the current lending landscape is for an asset-based loan?
Well, I'm going to pull a Jonathan. It depends. And I do think that the current environment is still good for obtaining loans. I think lenders are hungry to make loans. I will say this. I think they're probably a little more stringent right now, even though they are hungry for loans, because of the uncertainty surrounding a lot of issues. And one of those could be the deregulation of the industry. They don't know which direction it's going. Another could be, for example, I don't know that a lot of people have thought through what impact the tariffs are going to have, not only on lenders, but also on borrowers. And again, not directly on lenders, but if I'm a lender that's looking to loan money to a company that may be impacted in their supply chain by tariffs or through the direct sale of their products, I have to look at that very seriously and consider whether or not that's a credit I want to enter into to begin with. Those are the big issues to me, but I do think there are lenders out there that are still pursuing loans in the marketplace. I just think they're being a little more cautious than they probably have been in the past.
So to that end, as Phil points out, in the lending world, we use the term bankable. So the feeling is, from the elements that you put out with the size of that company, bankable means that the company is very strong and can get better rates and be financed by a bank. That being said, if you're bankable, everybody wants you. When you're not bankable, that becomes a different issue. So with the banks tightening up the last few years, there are many alternative finance companies went in to try to get those type of deals. So that's where I think the size of the company, the profit of the company, the type of collateral, and we're not even talking about the tariff issues. We're just talking about general business. The alternative finance market has come in big time, and usually they're non-regulated, so they're a little different than banks who are regulated. When they talk about tariffs, which now is, I don't know, 60, 90 days or less, that is an issue. Everybody has still got the balls in the air right now trying to figure out what does it all mean. I just did a panel yesterday on supply chain, and they did talk about it. So it's everybody has a different version on how to handle it. The main key is you just don't want to put out money willy-nilly. You want to make sure you have a viable borrower that has a history of good business, good capacity, good character, and all that in an industry that doesn't have any hiccups. If you could find that, great. So I think that's all. The devil will always be in the details.
Yeah, Jackie, one thing I'd add is you talked about 100 million in revenue, and revenue is great, but really what you're looking at is what your net revenue is, because even a company that may be bankable may have rising expenses and that really cut into their margin. So I think banks are going to look at that going forward because of their risk tolerance.
I think that's right. And I think, you had mentioned cash flow. And I definitely know of many businesses or some businesses that have had issues where, they've had to replace some equipment that, maybe initially it was $500,000. And now that they are replacing it in the current environment, depending on when it was, it may have gone from 500,000 to $1 million now, depending on the tariff rate. So one of the things, I guess, when you're looking at what type of loan you will go with and what lender you may go with, one of the slide 12 talks about the ability to sort of amend and extend or get a covenant light loan. Jonathan, can you explain the significance of those terms and what that is?
Sure. So amend and extend has been a term of art for many years among restructuring and solvency professionals. It basically means that the borrower is able to negotiate an amendment to the maturity date, to amendment to covenants. The extend is the maturity date. The amend is the rest of the changes, and basically it's kicking the can down the road. Instead of the lender taking collection enforcement actions, it's the lender agreeing to not do that, and in consideration, the debtor, the borrower, i.e. the borrower, will give certain consideration to the lender, like maybe higher interest, more fees, tightened terms. That's the concept of amend and extend.
Sometimes do they give additional collateral?
Sure.
Makes sense. Sometimes the devil, is better to stick with than bringing on a new party if you're having trouble.
Yeah, and there's a number of contexts where a lender may want to be more inclined to amend and extend. If you've got a macroeconomic climate where all your borrowers are having problems, then that's going to be a pretty significant factor. But in terms of particular borrowers, the lender's calculus is, well, if I take the keys away from the borrower, keys of the company, so to speak, and put in, some restructuring advisor, a CRO, it's all about, what's going to get the lender paid back more money, with more certainty and more quickly. And that goes right back to there's not always going to be a liquidation, or sale of the company, but there often is, and that goes right back to what we were saying earlier about the why the collateral value is so significant as compared to the amount owed is so significant. And then if you want to circle back to another thing we mentioned ever so briefly, doesn't really, I guess I'm segueing, it doesn't really go to amend and extend. Oh, no, sure it does. Sure it does. Because let's say I'm thinking in my head about personal guarantees. So a smaller company, a privately owned company, usually in order to get a loan from a secured lender, the principals will have to offer personal guarantees. Not always, but usually. At a certain point, when the company's successful enough, if the ownership is dispersed enough, you don't see PGs, but for the vast majority of Main Street USA businesses, you do. But if you're dealing with a company that doesn't currently have a PG, where the owners don't currently have PGs, you asked a moment ago, Jackie, well, are lenders able to extract more collateral? Yes, and sometimes they're able to extract personal guarantees where there weren't none before.
Right.
So in reference to collateral, just to mention it, there are certain players who are very sophisticated and they handle collateral specific. So if you're a lender and you're not specific to a particular collateral industry, whether it's equipment, whatever it is, you might bring in a participant to help you out. And I've seen deals be worked out that way. So it takes a lot of the leverage off the original borrower that he now has new cash coming into the business based on a new asset being collateralized that was there before, but not really have the sophistication to know how to handle that collateral.
And Harvey, you mentioned, maybe some things that borrowers should be looking at when they are entered into these loans. What are some of the things that you think they should be looking at when they're trying to determine which lender they want to go with?
Well, first off the bat, any sophisticated borrower should either be smart enough themselves or have a trusted advisor that guides them, whether it's their accountant, their lawyer, or consultant, somebody who knows the dealings, because it's not just the actual business content, but the different player that you're going to. There is certain history of lenders out there, like Jonathan mentioned before, the dastardly guys who loan to own, and there are other types of predator type lenders who are not so friendly. So there are different lenders that have reputations that if you have a problem, I'll work with you. I'm not just going to close you up right away and take the keys. I've had lenders say to borrowers on their personal guarantees, if anything should go wrong, I'll give you time to work it out. I'm just not going to go and take your personal assets. I'll continue to work with you. These are the different things that different lenders do. Some other lenders put in the covenants of the agreement, which you have to have a certain percentage of receivables, a certain percentage of inventory, and your fixed asset, whatever. So you could go into a default if you have more inventory that you need to borrow on than receivables, even though you're doing your business in a normal way. If it gets a little dislodged that way and you're getting more inventory reliant than receivable reliant, that is a change, and it could be a default. So that's why and it happened during COVID when people had to build up their inventories because of supply chains and everything else. So I think when you're looking to entertain shopping around, you should get a few deals. You should look at those deals, not just for pricing, but the covenants, and also have a history of how those lenders treat their borrowers. So I think those are a lot of different things to look into.
Harvey, you asked me and I failed to answer before. Your last question to me was a two-parter. You wanted me to discuss the concept of covenant light.
Yeah.
And Harvey, what he said really speaks to that, right? Because I think part of what Harvey was suggesting was sometimes covenants don't make sense given changing circumstances, but that's always in the eye of the beholder. The concept, let me just make sure, again, from a definitional perspective, we're all on the same page. A covenant light loan is merely a loan agreement that has few or limited financial covenants like debt ratio tests and stuff like that. And they're not uncommon, particularly in larger leverage loans and syndicated deals. And they're arguably, it's good from the company's perspective to have fewer covenants. It creates more operational flexibility. And there's fewer, technical default triggers. On the other hand, the concept of covenants is not a bad thing. I notice that if I weigh myself every day, I tend to maintain my weight. But if I go a week without weighing myself, a week later, I might not be happy. What I'm trying to analogize to, unless that was too messy of an analogy, if you're picturing me on the scale, that's just ugly. The concept is that early warning signal. If a covenant becomes out of whack, that's often something worth looking at, and reasonable lenders will look at facts and circumstances on the ground as things evolve, and we'll say, all right, look, when you entered into the loan agreement, this made sense, but you can ask for you can ask to amend or to what's the word I'm looking for?
Forbear.
Thank you. That's the word I was looking for. Forbear. And now, if you're dealing with a loan-to-own player, and I don't think they're all dastardly by definition. I've got a loan-to-own player that is, very honest about this is the business model, and if you can't, it goes to bigger questions. Are payday loan stores, in the context of consumers, evil? Or are they fulfilling a need? That's a moral question. Same thing, I think, if you're a loan-to-own player and you advertise yourself as such, I don't know that there's anything wrong with that. The point is, though, that if you're dealing with a commercial lender and it makes sense, it's economically rational for a commercial lender to agree to forbear or to actually change a covenant. That's been known to happen, but it does underscore this, as I'm hearing myself spew on, it underscores the need for a business to either have an attorney who understands the business terms, the business aspects, what the covenants, what the ratios really mean, or to have enough. And this is where I think some companies and their counsel fall down. The financial function within the company, the CFO, the controller, really has to partner with the lawyer to, the lawyer doesn't usually bring that kind of financial knowledge, the kind of, accounting knowledge to the table. And so it's a partnership so that the lawyer can educate the finance person about the legal impact, legal aspects, and vice versa. Most lawyers aren't going to know that, that a particular ratio is going to be almost impossible for a company to hit.
Right.
So anyway,
But Jonathan, and what we're all talking about, and it's very interesting when you talk about shopping around. When does the borrower need to shop around? When their contract is ending, when they're going into a heavy season, when do they do it? And if they do it at the time when they're already a problem, that's a lot different when you're shopping around and you're a problem. So it really as said before, it depends. And that's why there are certain lenders that will take on the tougher deals, and they have the history of knowing how to handle a tougher deal, handling it and working it out. So that's why it's very important when you go to shop. Why are you shopping? What is your time frame? And and sometimes the borrower could help you with his trusted advisor to get the best deal. Sometimes they're backed against the wall and they have to take whatever deal they can. A lot of us refer to the lender of last resort, like the Foreign Legion, because no one else will touch you. So that's where it all depends in business where you are. Are you considered a good company? Are you in trouble? If you're insolvent, it's another story. So that's all depends on the particular essence of the business. So the creation of $100 million piece of business is something that should get people to want to work with you. Then after seeing that and opening up the cover and looking through the pages, that's when it becomes important to figure out whether you're going to be able to get a legitimate loan that makes sense, or are you going to have to do something because you're in a dilemma.
And I think it's important for there to be, so obviously we've talked about how, we have the payment default. So if you're making your payments, that's great. But in addition to ensuring you can make payments, there are the other covenants that do tend to come into play. And some of them look at them from either, an operational standpoint or a balance sheet standpoint. And so, Phil, can you,
Jackie, before you ask me that next question, can I just add one point? Because I think this is a great place to add it. I agree with what Harvey and Jonathan and you said, but everybody needs to remember there is the overlay of good faith and fair dealing in contracts from a creditor standpoint. But it's not just from a creditor standpoint. It's also important that be from the borrower standpoint. And when you see a problem, as Jonathan said, identifying that problem early on and looking for a solution and seeking a modification or a forbearance, I find to be the best way to approach, because once a lender determines you're withholding information from them, it changes the whole landscape.
definitely.
There's another thing also, and you talked about, I think Jonathan mentioned it, about somebody that does something wrong. In the factoring world, the receivables, when they're bought they're owned by the factor. There have been times where customers send their money directly to the seller. So that borrower, that client gets the money direct. If they don't get that money over to the factor immediately, they have defaulted on their contract. And that is many times one of the reasons why factors will never want to touch a guy like that again. So that's just one little issue that borrowers have to be concerned about. And it could be innocent, but you got to be aware it looks like you got your hand in the cookie jar.
And what are some of the things, Phil, that when the lender, whether it's a factoring lender or an ABL lender, especially in an ABL lender's context, that they're looking at from an operational standpoint for the company, that they may be looking at from a covenant or, whether or not it makes sense to stay with this borrower?
Well, from an operational standpoint, I think the value of the asset and the risk of fluctuation in that asset is certainly something they're going to want to look at. The fact of the ability to lose any pledged assets, they're going to want to control that risk. And quite frankly, on the default side of it, having a process that will be manageable by the lender in the event of a default, because the complexity of dealing with an asset-based loan in the event of a default is greater than if you have just a hard asset like real estate. Everybody knows you can go out and foreclose on a piece of property pretty simply, but liquidating assets that are pledged in an asset-based loan have a unique characteristic and some real complexity there.
And do you find, and this goes to any of the panelists, that the borrower trying to negotiate either cure periods or other modifications to the default will assist the borrower in dealing with potential volatile markets?
It's very important that if you can do it, the borrower, before they go into a default, should be able to know where they are and go to the lender and say, listen, things are happening here too fast for me, or it's going to the left or the right, and discuss it with the lender. Any lender that has a borrower come in to talk to them and say, with their hat in their hand, I have an issue, is much better than it happens and then you got to work it out. And I think that's the problem. Is most borrowers don't have the confidence that their lender will do that. They feel once I tip them off, it's like telling your parent that you broke curfew, right? They don't, and that's where you have to have the good relationship between a borrower and a lender, so everybody understands everybody's position. The other thing that could break a deal is the losses. If you're losing money, there can be some confidence in there that if you're losing too much money, that triggers it too.
Hey, Jackie, I did mention monitoring and reporting, but those are operational issues that can be complex and difficult for some borrowers. Shouldn't be if it's a large, complicated business or complex business, but monitoring and reporting could be there. But again, I know what Harvey's saying, and I know that's how borrowers feel. And quite frankly, I think Jonathan may have mentioned, or Harvey may have mentioned earlier, about sophisticated borrowers. Even sophisticated borrowers need good counsel and advice, because it's hard to remain objective when you're in a default scenario and you're really trying to be protective. And counsel, whoever it is, and I'm not necessarily talking about a lawyer, it could be any other professional that has the expertise to walk you through the process, to be able to go to the lender and really frame the problem and look for a solution is really important. Because in my experience, whenever the lender determines the borrower has not been forthcoming when they should have been, it changes that whole relationship from that day forward.
And Phil, let's talk about, the company we were talking about. Let's assume that they have entered into a distress situation of some sort. And so what would be the bank's workout or restructuring options if the company does not want to file Chapter 11 or Chapter 7?
Well, there's several options there, and I know we're going to talk about some later, but really the first approach I would have on either side of it is a thorough review of the documentation, a thorough review of the defaults, a thorough review of the reasons for the defaults, and trying to see if any kind of forbearance agreement has the opportunity to succeed. And there are a lot of instances where forbearance agreements are successful. They need to be well thought out. They can be complicated documents. Everybody's trying to waive and reserve rights on both sides of the transaction. And so that does complicate it at times. The fact of the matter is, the lender really is in the best position at that point, because there's the default or the potential for a default. But I go back to, if I'm representing a lender in this situation, I do know that I've got some obligations to act in good faith and fair dealings. I've got the right to protect myself, but at the end of the day, I don't want the collateral. I don't want to have to collect on a guarantee. What I want is the business to turn around and me get my money back. The cash flow is really what you really want at the end of the day. And I think most lenders in this space are like that. I know there's some that aren't, and there's some that are more aggressive than others. But at the end of the day, my experience is most lenders do not want their collateral. They want their money back.
So Jonathan mentioned something before, which was really right. If you use the scale technique, Many lenders to go in and do their account audits, right? And they could understand what's happening more so than waiting for a CPA to give you a year-end financial statement, right? Or even the projections that the borrower will give, because they've done their own homework, sending in their own people, either third parties or their own employees that go in and do that audits. So they could now dictate to the borrower, look, I know you got this problem. Maybe you didn't know you have this problem, but now you have this problem. Another solution process, Jonathan and I have a good friend who specializes in what they call sub debt. And he'll come in and put money into the deal as an add-on so that they don't have to go into default, because now there's extra money being made available. So if the client did go into some sort of formula issue, over advance, et cetera, the sub debt will come in. The first lender still has first position, but it's extra money being put into for the good of the cause. And usually the borrower wouldn't know where to go for that sub debt. It would be the lender that would need to bring in that sub debt usually.
And for the audience that doesn't know the term sub debt, that means subordinated debt, i.e.,
Right.
it's coordinated to the first lender, so it's behind
Right.
the main bank. Jonathan, did you have any overlay on any of that?
No.
Okay. And so I know slides 13 and 14 sort of cover some of the potential alternatives that banks can look at. And so if the bank does not want to work things out, Harvey, so it's good if the bank does, and hopefully you have a lender that does want to figure that out. But if they don't want to forbear and there's no other sort of workout process that they see as an alternative for the particular business, what are the other options that the bank may seek to?
Well, the first thing a bank is going to decide, when we say a bank, let's say a lender.
A lender,
The
yeah.
first thing the lender has to decide, if they're underwater, and they now have to, what we call, cure that problem, because if there's a filing, they have a preference. They're underwater, and now a number 2 account is set up in a bankruptcy, and that's not something that they want at that time. Now, if they're in formula, and I should say they protected themselves over a period of time of 90 days, and they don't have to be a subject to a preference issue, then they might say, well, I'm over collateralized. It doesn't mean anything to me whether it tanks or not. I don't have the problem. But if they're underwater, they do. So that's one thing that the lender has to look at. It was mentioned before, I think Phil put it on the table, about liquidation value. If you could liquidate assets without a bankruptcy, you're going to get more money than you are if you go into a bankruptcy. Though if somebody could come in with a good bankruptcy plan, there are reorganizations in Chapter 11 that have been successful, that all you need is a freeze to freeze things so that you can get back, and now you freeze debt before anybody takes a shave and a haircut. So that is somewhere where that side could be good. There have been lenders that have used the Article 9 routine, where they take the keys, the present management is out, and Article 9 could easily lead to a liquidation that the lender does, or they bring in a third party to help with the liquidation. To include, there are people that do Article 9 reorgs that specialize in that. I know it was mentioned before about receiverships and ABCs and all these other vehicles. So these are all opportunities that a lender has to know exactly where they are. The other issue a lender has to be concerned about, if they're going to tank a client and that client has competitors, people are going to see that that company didn't work to help the guy out. They just were more looking to be mercenary. And that could be a long way when you want to now bring in new business and somebody asks you the question, are you going to tank me? You already got a history that you've done it. So a lot depends, and that's a different type of value that the lender has to think about. But if you're talking about the specifics of a deal, they have to know the numbers. and what makes sense in the deal. There, as Jonathan pointed out before, there are times where the lender has lost confidence in the management, and they'll bring in a turnaround guy, a CRO, that'll go in there to run the business. And therefore, management will have more proper value because they feel there's somebody in there watching the flanks. Many times, those turnaround guys are brought in to really turn the business around. Sometimes they're brought in to liquidate it, and sometimes they're brought in to find a buyer and to try to get the business sold. So there's different opportunities for the different type of turnaround situations, which is a whole industry in itself.
Definitely. And, if the company actually listens to them when they're there, that definitely is important. Jonathan, I think you also mentioned earlier how there can be sort of an ABC, an assignment for the benefit of creditors that a lender may seek to do. What happens if a bank decides to do that, or a lender?
So as a technical matter, let me take a step back. And you've got the slide displayed, strategic alternatives 4, right? So you just changed it. Good.
I'll go back to, yeah.
So there are alternatives for a distressed business that a distressed business will use affirmatively. And then there are alternatives that a lender will use. And there's an overlap. From a technical perspective, an Article 9 sale, an Article 9 foreclosure and sale under the UCC looks like it's a creditor remedy. It's thought of as a creditor remedy. It's the creditor that does it. It's the lender that does it. But often it's done in a cooperative fashion with the borrower / AKA debtor consenting and helping. And that's the term friendly foreclosure. In contrast, an assignment for the benefit of creditors definitionally is something that only the company, i.e. the debtor, the borrower, can do. Now, sometimes the company, aka debtor borrower, will do it at the behest, at the insistence of the secured lender. Basically, the secured lender with a figurative gun to the borrower's head, saying, this is what we want you to do. And the reason the borrower will do it is because that's better than the alternatives.
Jonathan, on the ABCs, it's limited, I guess, to certain states. It's recognized in certain states it's not.
So bankruptcy is everywhere in the United States. It's a federal law. ABCs are a thing in probably about half the states, I guess, maybe a little bit more. And where they exist, they're used with, I could have said this 3, 6, 9, 12, 8, what comes after 12, 15, 18 years ago. I picked years of 3 for no good reason. Each year I could have said ABCs are being used more frequently today than they were a few years ago. And that's a trend that's been continuing for more than a couple of decades now, and it remains true. It's very much like, in some ways, an assignment for the benefit of creditors is like a Chapter 7 bankruptcy proceeding. It has many more similarities than dissimilarities. Basically, the company, if I'm the company, or I'm the owners of the company, I can decide to file a Chapter 7 bankruptcy, in which case I hand over the figurative keys to my company to a Chapter 7 trustee. Chapter 7 trustee is often a lawyer, not always a lawyer, but often a lawyer who basically has a contract with the Department of Justice to act as a fiduciary to liquidate the debtor's assets. So it's true whether you're a person. Jane Smith can file Chapter 7, of course, and company XYZ can file Chapter 7. When company XYZ files Chapter 7, it's the Chapter 7 is assigned to a Chapter 7 trustee. Again, often bankruptcy lawyers, not always lawyers, and it is their job to liquidate all of the assets of the company and then to distribute them in order of priority to creditors. And if there's a secured creditor on the scene, the secured creditor's rights are not, still keeps its rights to its collateral. Juxtapose that to an assignment for the benefit of creditors. I'm the company. I sign a document assigning to an assignee / trustee. Remember, we have a Chapter 7 trustee in bankruptcy. In an ABC, we have an assignee / trustee. And we're making an assignment of all the assets of the company to this assignee / trustee for the benefit of creditors. And that assignee / trustee, most of the time we just call them the assignee, but it's properly thought of as the person or the entity that serves as the assignee is the assignee of the assets, but he's also a trustee of a trust, because I'm making an assignment to the assignee to be held of all the assets of the company to be held in trust for the benefit of creditors. That assignee liquidates the assets, just like the Chapter 7 trustee liquidates the assets, and then distributes the proceeds to creditors. There's some really significant differences between the way a Chapter 7 trustee operates and the way an assignee operates in an ABC. And I won't keep talking to tell you what those differences are unless you invite me to now or later. But many of the mechanics are virtually identical.
Jonathan, we've seen in ABCs, and basically, and you laid it out very well.
Thank you.
The ABC, the existing owner is out, and there's a new assignee that takes over that business. And we actually had a situation in New Jersey where an ABC was filed, and the debtor himself did not like the fact that he was being X'd out, brought in a lawyer, and the lawyer then was able to take it to New York and get a Chapter 11 filed. And I had to speak with the judge, and we talked about why did the judge in New York take it over when it was an ABC in New Jersey? And he looked at it and thought the value was added more to the estate by doing it that way, and was able to supervise the situation. It became a Chapter 11 in New York versus an ABC in New Jersey. Now, maybe that's an exception to the rule, but it just shows you the different mechanics.
Well, you're describing an unusual situation because, again, the company did not commence an ABC over the objection of the owner. The owner, quite to the contrary, the owner had to put the company into an assignment. But let's not get into that. You're describing one situation that is sort of an exception.
It sounds
Jackie,
like.
if I could, and I
Bill.
think Jonathan touched on this. One of the big problems in my mind is the lack of uniformity. And Jonathan, I think that may have been my comment, the lack of uniformity with ABCs throughout the United States. Mm-hmm. There's some states that have the structure in their statutes, but that's all they have is a structure, not how it's going to operate. And so it's really left to the discretion, and in a lot of instances, in a court of equity, on what's going to happen. Now, I realize that bankruptcy courts are a court of equity, but quite frankly, there's a lot more structure in my mind associated with a bankruptcy, which could be advantageous for the borrower and the lender. It could be detrimental to both, but there are pros and cons there. But there is structure there. And in a lot of instances, as Harvey pointed out, if you've got a plan and you can move forward with a reorganization, the structure of the bankruptcy court can provide a process that makes that more manageable for everybody. It can be a little more expensive, and usually is, but it does provide that process there. So in some instances, I'm really hesitating to even say this, but I'll go ahead. In some instances, a Chapter 11 can be a good thing.
Well, yeah, absolutely. A Chapter 11 can be a good thing. And the availability of an assignment for the benefit of creditors process, you're right, it's not available in every state and it's different state to state. The reason they tend to work so a state like Delaware, it's entirely supervised by a court, very structured. So the concerns you just articulated simply, I don't think you have those concerns if the ABC is in Delaware. Quite to the contrary, the state of Illinois, there is normally no court involvement whatsoever. And the reason the process works, it's kind of like why our fiat currency works. You know, the dollar's worth something because everybody agrees it's worth something. Kind of like Bitcoin too, I suppose. The point is that there's enough history that in this state, I'm in Illinois, and the professionals, you know, I don't know if you've ever said something to the effect of, even if I were a dishonest person, I'd be foolish to do something dishonest because I've worked, my lifetime building a reputation. Why would I throw it away for you, client, who's asking me to do something dishonest? Most assignees have reputation. Every assignee I work with has a reputation to protect, and the lenders trust the assignees, the debtors trust the assignees, and lawyers like you and me, when a random client calls up and says, "Hey, my customer XYZ Co. just did an assignment for the benefit of creditors," the most important question to ask is, where is the assignment and who's the assignee? And if it's, this is a fairly small industry, there's probably not more than 100 human beings acting as assignees in the United States, maybe 150, and at most. And so anyway, it works where it works because it works.
Yeah.
But you're right. In some places, it's the Wild West.
And I agree with all that, Jonathan. And the other thing that I would ask is, if somebody calls and says there's an ABC, if there's a court involved, the first thing you want to ask is, where's the order of assignment, where it's going to the assignee? Find out what the terms of the order are, because the order is only as good as the lawyers representing the parties involved.
And just dialing back, Jackie, to defaults, we didn't mention this, but many borrowers find their way over to merchant cash advance people, and that is a technical default on a lending agreement, but yet many do it. And not only do they take one, they stack them, 3, 6, 9, and all of that could be problematic. And the secured lender doesn't even know what's happening in many cases.
Yeah,
That's the reason for default.
that's very true. And I think we talk about merchant cash advances, or we will, in episode 5, I believe. That's coming up in a couple months. So one of the things we've talked about and touched on really is sort of this reorganization. And on slide 18, it takes you through the Chapter 11 that's been mentioned a few times. And so one of the things I think from the borrower's perspective to keep in mind is, when you're entering into this distressed situation, oftentimes you have to take into consideration more than just sort of what's happening with the company and what may be in the best interest of the company. If you're really distressed, you do have to then potentially think about, what will also happen, the interests of the creditors as well as the equity holders of the company. And so that may be why a Chapter 11 or another sort of reorganization through courts may be helpful.
Just as an aside on the Chapter 11 reorganization, which is important if it's coming in with a good plan. Some of the fears that borrowers have had to go into a bankruptcy, their suppliers might say, if I'm going to take a haircut, I'm never going to sell you again. So that is something in the old days used to be something of very much an importance. That's a little different. That's number one. Also, your customers, if your customers know you're in a bankruptcy, that's another license for them to now all of a sudden not want to pay you in full. Those are different issues, and there are pluses and minuses over the years. I just wanted to point that out in this discussion.
And I know we had mentioned Chapter 11, and Phil, you talked about how they can, going through a reorganization can be more expensive. And so one of the things that that's available, it's what's called a prepackaged Chapter 11. Can you talk about that? Is that popular? Does that assist with costs?
I think I'll just touch on a prepackaged 11. It's got to really be done professionally. It's got to really be looked at the whole details. There was a bankruptcy a couple of years ago, prepackaged 11, that actually paid 100 cents on the dollar within 30 or 60 days. It was a big mattress firm, and it was a lot of people that were very much involved and supported it. You got to really know what you're doing. It's not just something you go in on a guesswork. So prepackaged 11s have been very important. Matter of fact, there was a major lender back in 2008 that actually did a prepackaged 11 for themselves. But it has to be done with a lot of authority and knowledge, and it could be very helpful. But if you don't have all the proper structure to it, it's not going to work.
Definitely. And Phil, did you have any additional thoughts?
I'd like to know what everybody thinks about, because I think this is something that's really a defining point for boards and management. Once you recognize the company is insolvent, the duties are going to shift where prior to insolvency, most boards have a duty to all of their shareholder base. Once insolvency is determined, then that fiduciary duty shifts to creditors too. And once you file bankruptcy, it is directly shifting to the creditors involved in the bankruptcy.
Oh, I don't know about that.
Well, maybe not.
Company doesn't need to be insolvent to file bankruptcy.
Well, that's true. But
Phil, to your point, before you even do the insolvency, the directors and officers have to be concerned on their insurance policy. Where do they stand with that? Jonathan mentioned before CROs. A few years ago, there were a lot of people that said, hey, if I'm going to bring in a CRO, I'm telling the insurance company I have a problem. And it could be a problem. Somebody just told me the other day that there was defenses about how to plan that out so that you can get the CRO in there but not lose your insurance. And it's a way of how you file the policy. So there's a lot of elements to that. That might not be exactly what you're talking about, Phil, but I know if I'm a director or an officer, I have to be concerned for the D&O.
I would agree with that. But Jonathan, you would agree that there's a shifting responsibility once insolvency does occur.
Yes.
Yeah.
Yes.
And that's really what I was trying to get at. I went a little bit broader than I meant to.
I'll keep you in line. No, but your point is, and really probably being too academic in that comment, because as a practical matter, we're both going to advise our boards or at our director at our officers that you got to operate as if you're insolvent, because in terms of, and we're already over time, but the concept of you got to do what it takes to maximize the value of the entity, and that's a whole different webinar.
I agree.
That is, but it is very correct that once you've entered that zone of insolvency, and the hard part is determining that, the duties do shift. So I'd like to thank everyone. We are a little bit over time, but I want to thank everyone for giving us an additional 5 minutes of your time as we talked about dealing with defaults. Thank you, Phil, Harvey, and Jonathan, for your fantastic insights as we sort of deal with this topic. And
Always a
we
pleasure to
encourage you-
work with this august group.
Thank you.
Thanks, all.
Always enjoy it. Excellent job, all of you.
Thank you.
Have a great
Thanks all.
afternoon, everyone.
Bye.
Bye.